Thank you for joining and welcome to our live Q&A for July. We have a bunch of questions from you that we will be answering, but also if you have any questions that come up as we're talking, feel free to write them in the chat and I will be sure to get to them. Otherwise, I think we're ready to dive in.
Hey, everyone. Good to see you. More or less. I see some people, some still photographs.
Yeah. All right. So we're going to start this time with some Supreme Court questions because of the end of the term that happened last week. So the first one is, could you please explain the major questions doctrine and how it can be applied?
Maybe. Because as Justice Kagan said in dissent, not just this year, but last year in an EPA Clean Water Act case where it was first used, when there's a question of statutory interpretation that the majority can't otherwise figure out, the major questions doctrine magically appears. So I'll give you the cynical version, and I'll give you the straight version first and the cynical version second. The straight version is, all right, what the court is doing is interpreting whether Congress wanted to give agency a certain power. The agency is in front of it asserting, we have this power. And look at this statute that Congress passed that was a general grant of authority over us, and also a permissible grant of what we can do. And look, here's what we did do, and here's why it fits. And typically, and this is like since the New Deal, Congress has legislated more and more expansively, left more and more deference to agencies on the theory that they have certain expertise and the unspoken theory that Congress can be a little lazy, or that's not why they came to Washington for. But the state of play was always, until 2 years ago, that you get a supposed grant of power, or maybe broad one, from Congress, and then an asserted authority or power that comes under it, and you just try to say, all the power in the world to do this, and so it really would be power to police the clean air and the like. Okay, that's the and further to the kind of proponent version of it. The court has said, this is just common sense. When there is a big question, either practically, economically, or legally, wouldn't you think Congress would really want to be specific before turning over that authority to an agency? So we do too. And in order to effectuate that instinct, we are going to look for really express instructions from Congress, and just to ask it that way means the agency's power is gonna go down. So I mean, even on any way of looking at it, this is a way that the court has taken power away from Congress and agencies and really aggrandized themselves with it. Okay, so but the defense of it, we're just doing regular statutory interpretation. The criticism is, look, we've been doing regular statutory interpretation with big grants of power for a long time. So let's go to the Biden student loan program. The HEROES Act said when there are emergencies, Congress has the agency has the power to waive or modify certain requirements. And the Department of Education said there is an emergency. That's not up to them to determine. It's true that emergencies have been declared by president after president and kind of never rescinded, but that's an issue between the executive branch and Congress. And then the department said, so we're going to waive or modify and what a certain amount of the payments due under the student loan program to us. And the dissent said, Justice Kagan, waive, modify, big grant, but so what? We always deal with big grants, but the majority said major question. Therefore, we want to see Congress having actually said something about waiving or modify student loan programs. Of course, that won't be there. Otherwise, the question would never come up. Now, just a little final note about how this came to be. nobody ever heard of the major questions doctrine, except in conservative circles, it became a kind of hobby horse. Maybe in the aughts, in the 2010, there was actually a Federal Society conference about the major questions doctrine. It was really understood as a way to trim the sails of agencies and agency power, which a lot of conservative legal thinkers don't like. They think it's not responsive, too far from sort of the political base. But no one had ever heard of it, basically. And then it first shows up in a way anyone saw in 2017 or 18, a dissent by then Judge Brett Kavanaugh, who even in his dissent said it does have a kind of know it when you see it quality. And then out of the blue last year in this EPA case, boom, the major questions doctrine is just spouted by the new conservative majority. And now it's considered a, official doctrine, but it would still, I think, be the criticism of it that it's like just been made up out of thin air as a way to strike down agency action for reasons that it's not because it's big, but for reasons that are part of a sort of independent agenda on the part of conservative scholars and the 6 conservative members of the Supreme Court.
Okay. All right.
So that, little long and legal, I know, but it's kind of necessary. Even though it's such a simple doctrine. Yeah.
Another one from this term: could the diminishment of public accommodation from 303 Creative reduce protections for people with disabilities, and how?
For sure. I mean, look, so 303 Creative, as happened in all the big cases at the end of the term, 303 Creative, the student loan case over major questions and standing and affirmative action, there's a big sub-argument between the majority and dissent about whether they have ignored precedent. And in 303 Creative, the majority is at pains just to say, no, it's always been true that the government can't compel your speech. And that has always been true, except this, not in this setting at all. So since the Civil Rights Act of the 60s and the federal government and a lot of anti-discrimination ordinance, as there was in Colorado from the 80s, states have said, look, if you have accommodation, essentially a business open to everyone, you can't discriminate on the basis of, and then it varies by state. So almost any statute will have race, ethnicity, and national origin. Some will have sexual orientation, as the statute in Colorado did, and some will have disability status, although there's a whole different body of law, the Americans for Disabilities Act, as you may know. The big problem with 303 Creative, as I see it, is there really isn't a limiting principle. You have a website designer, website designers put together schedules or gift registries, but she's asserting somehow that website she's designing is tantamount to a message proclaiming to the world, hooray for same-sex marriage. And it's certainly true. The government couldn't make it as, say, a condition of voting that every citizen has to stand up and say hooray for same-sex marriage. But that's never been what these things are about. Rather, if you're a business holding yourself open to everyone, you can't turn people down on the basis of any of these protected characteristics. And what the plaintiff was saying in the case was, I have religious views. Marriage is between a man and a woman. I don't think that same-sex marriage is legitimate, and I don't want to celebrate it. Fine. Okay, so far she can, be in her living room saying boo for same-sex marriage. But therefore the statute in Colorado that says, because I'm open for business, I have to permit same-sex partners to take I have to do business with them. That's where I draw the line. Now stop and think about that for a moment. The easiest example would be somebody who says, for whatever reason, it doesn't have to be religious, I really would prefer not to do business with disabled people. It's a bad look for my business, whatever it would be. But this is my view. That's a crazy view, of course, but hostility on the basis of sexual orientation is a little crazy. And racist views are reviled, but maybe not absent. But the main thing is then the analysis. There's no reason under the court's analysis in that case that saying I'm creating this website, so it's saying yay for disabled people who decide to get married. Well, that's not something I believe in. I don't want to be forced to say that. So it is this next step where courts take businesses open into the public in general and say, have permitted for the first time in this case someone to assert, if I have to do business with them, that sends a message. So everybody who defends the case would say, oh, don't get so hot and bothered. For example, the people, this won't be used to discriminate against other classes. But the argument has a long history. And for instance, in the civil rights era, people who were forced to serve African Americans said, this is a violation of my First Amendment rights. And probably in, Baton Rouge, Louisiana in 1964, serving African was sending a message that you're okay with integration. So it really does seem pernicious and to allow all manner of discrimination. The court, or at least its defenders, are at pains to say it's very, very narrow. But by the reasoning of it, which is basically, if you think you're sending a message and that the government can't compel you to send, you don't have to obey an anti-discrimination ordinance. That seems to go mighty far. And it certainly had nothing specific to do with discrimination on the basis of sexual orientation, except this woman's belief was anchored there, but others could be anchored in other sorts of protected groups.
All right. We have a couple
those are two pretty thick legal questions,
yeah.
but I gather that's what you came here for, at least in the Supreme Court stuff. So go ahead.
Absolutely. We have a couple kind of bigger picture court questions. One is from the chat. Since the Supreme Court gifted itself the power to determine constitutionality in Marbury v. Madison, could it ever be rescinded, and how?
Wow. I'll start with the short answer. No, not in this world, in this lifetime. So you could say they gifted themselves. It's for those of you who haven't been to law school or haven't heard of Marbury versus Madison, is the kind of fundamental fountainhead case in probably the most famous case maybe of all time, but it's where the Supreme Court, per Justice John Marshall, interpreted the Constitution to permit the Supreme Court to strike down laws that didn't accord with the Constitution being the higher law. So I think most people would say that you can imagine it was their decision, and there are people who point out, well, other branches have to take oaths to the Constitution also. But I think it's as firm a foundation and pillar as anything can be in constitutional law that Supreme Court has this power. Now, so what would it take? It would take a constitutional amendment to say they no longer do. Would the republic fall? No, it wouldn't. There are some, advanced democracies where it shares. Supreme Court makes up its mind, then others can make up their mind. That was actually the position that Lincoln espoused before the Civil War in the Lincoln-Douglas debate, saying, okay, they made a decision about Dred Scott, but I'm not going to accept the overall principle. And Meese did something similar in the 80s. There's occasional tussles of that sort. But I think, for example, I've made it clear, I think it's a really, really, really extreme conservative court. Nobody on that court would question Marbury versus Madison or the ability of judicial review. So it would be, that's what I mean by a different world. But the way that world would come into being is, for whatever reason, a constitutional amendment was passed. And then we would just stumble on a little bit with different, Supreme Court would make rulings and Congress would say no and President would say no. And it would just be a kind of, informal tug of wars. But the United States of America would stand, but the Constitution, as we know it, would not.
One more on this general topic. Is there no other recourse for getting a Supreme Court justice out of the court besides impeachment? What if they commit an obvious serious crime? Couldn't Biden or the Senate or someone besides Congress force ethics rules on them? Would an executive order be no help? Multi-pronged question, but you got the gist.
I'll start with the first one. Yeah, that's right. Nothing lawful. If you're thinking of felonies, well, you don't come here. But right, they commit a big crime, impeach them. They can, theoretically, this hasn't come up, but you could convict them. They could be in jail, whatever. They are justices for life, enjoy protection, but unless they are convicted of high crimes and misdemeanors. It's a little bit like we're messing around with, the weird hypotheticals with Trump. Okay, but what about these ethics rules? They alone are not bound by them. Could an executive order bind them? I don't think so. Executive order can only really regulate the executive branch. It's often powerful because the executive branch is so big and powerful. If you tell them, I do this kind of business practice, often so many companies will have to follow suit. Could a law passed by Congress, signed by the president, do it? And this makes it as clear as can be. They have to follow, here's the code, we mean it, etc. And what would happen? Well, go to the last question of Marbury versus Madison. It's very possible that the Supreme Court would take that up and say, sorry, we think that's a violation of the separation of powers, and we are hereby striking it down, and it's unconstitutional. And at least in our culture, that would probably stand, although there'd be a real hue and cry. So in terms of a ethical set, we have to hope. And one more thing there, Congress has recusal rules that apply to all the other federal courts except the Supreme Court, which is basically just exempted itself for no good reason. But Section 455, 28 USC about when a judge should recuse him or herself, that's law. So Congress could do this, and there would be arguments on both sides, but it would be up to the same 6 or 9, or whatever you think of them. Likely though, they might say something like, "Oh, it's precatory. It's thanks for the recommendations. We'll follow it, but if we don't, that's you can't do anything, etc." So, as a legal matter, maybe a law, not an executive order. As a practical matter, it's dicey whether that would do it, but you could at least hope for the court to impose something with real teeth. In these latest scandals, you have Alito and Thomas trying to defend their ethical lapses, and that by reference to certain bodies of law. That it's not very persuasive, the justification, but it's at least a kind of concession that there are guidelines that they're supposed to follow, just they refuse any consequences if they don't.
Switching gears a little bit, this one is from Becky Stowe, who's on the call. My question is, what the heck is this preliminary injunction by Judge Doughty, I believe that's how you pronounce it, in Louisiana?
Man, it's about the crazy. I think this it's both so sweeping but also so crazy. It's really crazy. The U.S. has already appealed it. What I can just kind of say what it purports to be, but there's a suit that a couple Republican state attorneys general have brought, and they've basically said, when the federal government has been meeting with Google and other social media on things like, how do you get false stuff off the web so people will take a vaccine because there are lies on there that make them doubt it? Well, those lies, we'll say falsehoods, because I don't want to load it up, because what the lawsuit is saying are things like, that those aren't falsehoods. Those are just conservative. Those are just positions in arguments. And guess what? They happen all to be conservative people who take these. Same with other things about, whether Trump won the 2020 election. That's not a falsehood. That's just a difference of opinion. And so that's for starters. And then the next step is to say, and in working with them and trying to exhort them to say or help the media companies get falsehoods off line so people aren't influenced by them. That's really the federal government, the deep state, compelling speech. Now we have a little bit of an example of how this notion of compelled speech can matter. And moreover, it's viewpoint discrimination because it's all about conservative things. So, any one of those propositions would make any respectable judge, go into chambers and guffaw and then come back out. But this guy, a not very distinguished Trump appointee, bought it hook, line, and sinker. And there we have another problem that has come up in other cases, enters an injunction that purports that it does, until overturned, to just freeze all of the agencies in government. You can't now, it's not even exactly clear what, but talk with Google about threats, talk with Facebook, work with them at all, which is, when I was in government, it's very much part of what you do every day, not to mention Google, and those guys have a right to petition you and get your views and work with you, etc. So it is completely outlandish. Now, in order to appeal a preliminary injunction, the Solicitor General, the one and only person occupying that office, has to approve it. And it's usually a big process with different constituencies weighing in. These are the ones who usually are supporting strong executive power. These are the ones supporting civil rights. Today, like within 24 hours of this total nutwing injunction, the United States appealed. So basically everybody within the executive branch saw right away that, among other things, it's dangerous for the U.S. not to be able to help with public health as it's as misinformation is propagated on the internet. So you gotta hope and believe that the Fifth Circuit will make quick work, at least of the preliminary injunction, which the judge below entered, saying, I think when we go to the merits, that the attorneys general are going to win, and plus they're getting terribly hurt by not being able, by this ongoing communication between DOJ and the social media companies. So I'll freeze the linebackers and hear the case. I think what the Fifth Circuit will do, certainly should do, kind of has to do, is take away that preliminary injunction. But then it'll go back for trial to the same guy who they'll put on evidence, etc. So he'll still have the power to be heard again, not in nearly as pernicious and dangerous a way. So that's my kind of best summary of what it is. It's complete nonsense and sort of a paranoid conspiracy made into law, and hopefully we'll hear very soon from the Court of Appeals, which will set a briefing schedule, a very fast one, and then hopefully we'll dissolve the preliminary injunction. Does that do it, Becky? Man, I feel like all my answers today are just law school material. So I hope they're not
complicated
too,
questions.
arcane.
I understand.
They really are. That's all I can say. I can see Becky's name. If not Becky, are we okay? Yes, thanks. All right.
She says yes. Yeah.
All right.
All right. Turning to some of the Department of Justice investigations. This one is two questions that I'll ask together. What are your thoughts on the speed of the Trump investigations? There's been a lot of dunking on the DOJ about how they were extremely hesitant to investigate. There's absolutely another side of the story. What would you say are the possible challenges the DOJ was facing after taking over from the Trump administration? And then I'm just going to add this other question on, which is, has the DOJ waited too long to start bringing the case against Republican insurrectionists?
Yeah. Well, so Brian, is the person on the line, Olivia?
I don't believe so. No.
I'm going to take the Republican insurrectionists. I don't know if that means Trump circle.
Oh, I think that I'm reading that as meaning the people in Congress, most likely, like who.
Oh, I see. Oh, wow. Okay. All right. So a couple things. Look, I do think there's another side of the story. I've been publicly identified pretty strongly with it, and pilloried by people who are otherwise seem to like or appreciate my thoughts for being too much of an apologist to the DOJ. And it's true, I worked with Merrick Garland and think very, very highly of him. It's also true. Well, so let me start with they didn't wait a year to investigate. Investigations on some of this stuff, even including the sort of DC government types, started around April. But it's true that they had a playbook, and they went by that playbook, and that playbook said, first, we have the biggest crime ever, and they've now charged over 1,000 people, and we're going to go after that and work our way up, which is what they've done. So the charge is basically, why didn't they do it by 2 tracks simultaneously? Why didn't they throw the playbook out? And my take on that, I'll say one more thing, which is, even given that, and that they were really busy and really earnest. And what Garland said always was the fact there. They were going to go after everyone. I think there was, a few month period where they, maybe they could have sped things up. And it's been so dramatically sped up since Smith has come on the scene. But he inherited a lot of work that had been done. If you read carefully, like the investigative files and stuff that come up, to just take the Mar-a-Lago case, the FBI and others were involved before we knew. So that is, part of it. But people would say, in a case like this, you should have thrown out the playbook. I understand the charge. I can see it. And if Garland's to be taken to task, which I don't do, for the most part, it's because the idea is he should have realized, obviously he realized, he should have changed the playbook to go faster, understanding the risk that we're looking at, that anybody with any sense knew we could be looking at, of an election cycle in which Trump or someone else wins and the whole prosecution kind of crumbles. But this is the way DOJ generally works. I'm from Pittsburgh, and we're having right now the first death penalty trial under the new administration for the Tree of Life massacre. It happened in 2018. That's 5 years. That's not unusual. So the charge really has to be something like this. They should have changed their playbook in order to be attuned to the possibility of the election cycle, and let that dictate things, and and really push forward because of it. And instead, I think Garland was determined to be not driven by the election cycle and by politics, understanding the risk, which now seems exquisite. It feels in a way like we're just on the borderline, and couldn't we just have a few more months for charges they would bring? It feels like, a bit of a shame. But I basically, so summary, they were doing a lot all the way through, but first and foremost, they wanted to approach the case not by the election cycle, not by politics. Garland was leaning over backwards to play it straight in that way. And that's led to a situation, because of the disconnect between a normal political timeline and a normal DOJ case life cycle, where we're looking at a possibility that if Trump runs and wins, or maybe even other Republicans, that the whole thing will come tumbling down. Of course, in that instance, the whole country is it's sort of a bet on the whole country in a way, especially at what Trump has promised to do. So, I cannot blame Garland for playing it ultra uber straight in this situation, except I acknowledge a little bit of time, not this 2 years, but a few months where they could have done a little more hurry up.
All right. How much do you think Jack Smith will put up with the delay tactics from Trump before he takes action against Judge Cannon, and will he have a case? Does that make sense?
Really good and a really hard. No, it makes sense. So she does now to just, was arraigned today. His lawyer, what if his lawyer shows up and says, he wants more time? I think the short answer is they are prepared, or they're planning to live with her, unless there's one overwhelming legal issue that can cause a delay, and that's this Classified Information Act. In general, she said, I want all the motions, and we know a lot are coming. Corcoran and prosecutorial misconduct. I want them by a date certain. Maybe it gives a little, but we're talking about on a schedule. They still haven't responded to the schedule, by the way. That's that's coming soon. But on a, let's say she said something for February. That's still what we really want, is to have a trial finished and go to a result by the summer. Of course, if there's a hung jury, that's a problem. But it's only fair, I think, to the American people to know whether the guy they're voting for is a convicted felon. Asterisk. He'd still have his case on appeal, and if he won, he wouldn't have to pardon himself. He could just order the DOJ to kill the prosecution. But in terms of Smith, I think, week here, week there, they've already, jerked him around a little bit with NALTA. Not much to be done. But when it comes to the classified haggling, which will be the best opportunity for Trump to delay, that's where he'll push. And if in particular Cannon gives a ruling that they don't like, that's something you can appeal. If and when they appeal, then there'd be a separate judgment. Do we try to force her to be recused also? But basically, unless things really drag on in the classified area, I think they're determined to live with her. And that's a problem, even if she's not as patently result oriented and favored toward Trump as she was before. And why wouldn't she be? But even if she isn't, she's a rookie judge. She's done only a few little criminal trials, but Trump's lawyers are going to stand up and pound the table and say, we need these 4 months, or it's a violation of due process. And it takes a strong, experienced judge to push back. So she's a worry, but that kind of thing where she just doesn't have a strong hand, they kind of don't have a play. It's not very easy to recuse someone, and they'll need to be going up there with a pretty patently inaccurate ruling.
Okay. And here's a related question. Assuming Trump will soon be convicted of one or more serious crime, we all know he'll appeal. Could his appeal make it all the way to the Supreme Court? And what do you see as his chances? And this person also adds, cheers from Canada.
Oh, hi. Hey, mate. No, I'm sorry. Geez, that's totally wrong. Can we just rewind altogether on that? For sure, he can play out on the appeal. And what I just talked about is the most likely means of some question having to do with classified information, and the judge. There's a whole game back and forth about how much classified information the defense can have. And there have been cases in which judges have ruled so much that the government backs away from the case. They've chosen these 31 documents pretty carefully, and I think they're ready to reveal some. But that's the question. I think he'll have a whole grab bag of issues, including how she'll rule on the motions we haven't seen. It's very, very hard to predict without knowing the actual issue. But wouldn't that be, at least there's a screenplay that people are writing, and that's how it all ends 4 years down the line. I certainly don't trust this Supreme Court, although I also think that the very extreme people he's put on are not looking to be remembered in history as they would as the court that freed Trump. But man, to really size up the odds, we'd want to know what the issues are. Nothing like that he said so far about prosecutorial misconduct, anything like that it's a possible issue. But there'll be meaty things coming up, and so the court certainly has shown that they're unafraid to reverse, based on their ideas of what's wrong and right.
The charges against Trump in Georgia might include conspiracy. If so, would all the people on his end of the Raffensperger call be liable for conspiracy too?
Really good question. I can be short on this. Conspiracy means that you made an agreement to do something unlawful and taken some action, some overt action, which is always there. So no, I think you'd have to show the people there actually agreed to further the unlawful objective. So, Giuliani goes down there, Mark Meadows goes down there, but people who are just doing their job, hanging around the Oval Office, I don't think you would see beyond a reasonable doubt they entered into an agreement with Trump.
Okay. Another question about Trump's allies. Do you expect the DOJ to ever indict the people known to have been in the Willard War Room on January 6th?
Really good one. So from the start, these guys, there's been the whole marauders, Trump, etc., and then some middle ground people who are kind of a bridge. The Willard War Room has some of those, Flynn and Powell, but it also has some people, Mark Meadows, I think, is in the Willard War Room, who are clearly also in the tight circle. Giuliani, I think, is maybe in the Willard War Room. I have to review. Those people I do expect. I think other people are going to be indicted, including potentially in Georgia. The question is these sort of shadow figures whose real job is to somehow connect. Guys like, Mike Flynn, will they be indicted? The main reason to do it would be to put pressure on them to give up the goods on Trump or the real sort of official actors whom they seem, we don't, remember. Axiom number one, Trump can't testify. Axiom number two, there's always a mountain of evidence that we haven't seen that of course Smith has. But if it seems like they've gotten to that level without trying to really force cooperation from that kind of shadow world of folks. So right now, I don't think we're seeing it. But one other thing, this goes back before, even if Trump's like the DOJ is in this for the long run. If they're not ordered to stand down, they'll he might bring a January 6th prosecution, but on a small case, that doesn't mean all the other stuff just sort of goes away. So there is a whiteboard up somewhere in his offices that has 150 pictures on it, and that includes everybody in the Willard War Room, and we know they're going after the lawyers. I'm now I forget now, is Powell in the War Room? Sometimes Jen Alice. So, but taking the question to be, will they prosecute people whose only role is that? Right now, we don't have outward signs of it.
Next question. How is it possible that people like Jim Jordan can totally ignore subpoenas and still serve in Congress? Is it as simple as Congress policing Congress so no one else in government can do anything about it now that Republicans hold the majority?
I'm really tempted to say something that's just slightly vulgar. Oh, but I don't know. So I'll just give the punchline, because maybe it's a question and there's the punchline. The punchline is because they can. And that's, basically the only way to get at him is with effective motions for contempt, ethical violations, and the like. The hypocrisy is screaming, loud and now, of course, there could also be a political check, like his constituents say, we don't want this terrible lying sack, but that won't happen. On the contrary, the examples of Marjorie Taylor Greene and the like, in some ways Trump, seem to be the more outrageous and mendacious, the more their immediate political base likes them. But so are they, will DOJ charge with a crime for all the lying? No, not only. It's really a violation of the rules of Congress and just like rules of decency. And one would be a political check, but that's, members of Congress have their own bases, and the other would be ethics rules. And you're seeing some people now, including Santos, having some ethics stuff, but it's still controlled by the Republicans. So basically, it's not formal immunity, but it's practical immunity. It's up to their colleagues in Congress, who are generally at war with the other side and totally also dedicated to the big lie, almost all of them without exception. So, and no one wants to cross Trump in addition, to the extent they're not. There you have it.
Okay.
Really sad state of affairs.
Yeah. Can you please run down the facts and merits of the Hunter Biden case?
So I think I can. What he has pleaded guilty to, but the court hasn't accepted yet, is 2 misdemeanor tax counts, and then there's another involving diversion. They're pretty small. So in 2016 and 18, I want to say, he is in the depths of crack cocaine addiction, and he files tax returns that are false, understate his income by, well, I don't know if it's a couple $100,000, because he has since paid back all that money. Now, as you can imagine, that's not a get out of jail free card. If you don't pay your taxes and you lie about it, you can pay them back and you're still subject to crimes. It's not something that happens a lot, but it can happen, and it's hard to protest. He did commit a crime. Then there is a firearm violation. What was that? It's when he procures a firearm, has it for like 2 weeks before his girlfriend throws it away. But he says he's never he lies about his drug use, knowing that he wouldn't get it otherwise. And as to that, they're going to charge him, but under a diversion agreement, so that if he, doesn't have further offenses, it will go away. That's a felony charge that will go away. All right, so that's the package. Now, you've probably heard there's a Republican brouhaha saying he was let off easy and the like. And what they seem to be referring to, there's just been all this crazy stuff swirling around business he's done, that he did in China, that some people, I think it was just today that they said, oh, the cocaine was found in the White House, so that's Hunter Biden's. There's no end to what they'll say, because it's a way to get at his dad. So there are different kinds of accusations having to do with business income in China, but even those they have to state as tax violations or failures to fill out, register as an agent or fill out financial disclosure forms and the like. So the basic idea is, by the people who think he's getting a slap on the wrist, I'm not among them. I think, among other things, this is a really losable case for, if the special counsel has had if Weiss were to bring the case, he's the holdover U.S. attorney, Trump U.S. attorney, 2 misdemeanor counts of a guy who paid it all back and was in the depths of drug addiction and turned his life around. That's not a happy big jury appeal case, I got to say. So, I don't think you can really fault the DOJ for the deal. But the people who do fault them say he could have had, based on nasty, or at least kind of, business where he tries to leverage his dad, not against the law, but tax violations and the like. And really what they're looking to do is surface those allegations to make it seem, especially that Biden, who said he never had anything to do with Hunter's business dealings, Biden kind of looks bad, and you can, sort of get some of the dirt, kicked up onto him.
Just a couple more questions.
Oh, this is fast.
I know, it's flown by. Could President Biden sign an executive order to make Election Day a federal holiday? And would that action be enforceable to ensure all American citizens have the day off to participate in the electoral process?
Yeah, that's an excellent question. I think the short, I think the question is, would he need Congress as well? He'd probably get, I don't know, maybe the Republicans would be against it. So can you just, I'm trying to remember the process by which other things have become federal holidays. I think you need, the truth is, let's give him a mulligan on this, or give me a mulligan. I'm not sure. My best guess is you would need congressional action as well to have a full-fledged federal holiday. But the truth is, I'm not sure. So let's if you can stay a little later, Olivia, I will too, because that question shouldn't count.
Sure. And we have one more, which is a fun one. What is your favorite fictional legal book and why?
That is a fun one, but would that be the last? Because I want to take one more for the one I just whiffed on.
If there are any others in the chat, write them
Oh,
now.
okay,
How
so
about we give
we've
people-
actually, well,
Yeah, we've actually gone
if
through
we've,
them.
okay, now I don't feel bad about the long-windedness
Okay.
either. Okay, my favorite, it's the first thing. So To Kill a Mockingbird is a masterpiece, and I read it at an age when it was deeply affecting and beautiful, and so many people have that feeling. I was younger. I mean, it's an idealistic view in a way, even though terrible things happen. The first, so I think the trial is a really good and riveting novel, except it's almost anti-legal. It's almost not legal in the sense of it has such a dim view of the social order and the legal system. So To Kill a Mockingbird and maybe Crime and Punishment, which also is less about the law than about criminals or the kind of convict's mind, but a beautiful psychological study for that reason. So I'll give those both honorable mentions and go with To Kill a Mockingbird, even though I know it's kind of the cliche-ish choice, but there's cliches, there's reasons for them. So
Nothing
Kill
wrong with
Mockingbird.
that.
Okay.
All right. That is all we have time for today. Thank you everyone for joining.
Thank you everyone for
Be
joining.
sure to tune in next month when we have another Q&A.
And if I might mention, it will
Yes.
be someone else moderating because Olivia Henriksen has been so valuable and integral to the podcast, is going on to further career steps as she has every right to do, because she's a rising star that we were happy to get for the time we had her.
That is very kind of you. Thank you, Harry.
All righty. Bye-bye, everyone. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.